Good afternoon. We will call our last case of today and our January call. That is Doe versus General Motors. This is a 15-minute mini oral argument on the application. Welcome, counsel. You may reserve some of your time if we do not use it up, and we ask that you do your best to keep track of that yourself, and you have 2 minutes of a free fire zone if you wish.
May it please the court, thank you, Chief Justice Clement. Val Washington, appearing on behalf of appellants. This is my first time in front of the court, so if I stutter a little bit, you'll understand the awe that you inspire when people come in front of you. But I would like to reserve a couple of minutes at the end, if I may, please. The purpose of coming today, and I thank the court for allowing this oral argument on the application, is discovery. How am I supposed to plead and then prove that there was an intentional act with no discovery? I submitted discovery with the complaint. It was timely responded to, and the response was, court doesn't have jurisdiction, therefore we're not going to answer. And I had to, at that point, file a motion to compel, which of course was subsumed by the motion for summary disposition. But I'd like to say this, and as you hear the arguments today, keep this in mind. What was the essential business purpose of using the metal storage blocks? That was a question that puzzled me. The dissent asked the question of counsel at oral argument in the Court of Appeals, and the answer was, I don't know. We all know what a furnace is, we all know what a drill press is, we know what those kinds of manufacturing pieces of equipment are. But what is the purpose of the blocks, especially when you use the metal ones as opposed to wood or foam, which would have if you're trying to protect the equipment, it would have the effect of protecting the equipment and also protecting the employees. You don't have that in this case. You have my plant, my call, my dies. And he missed one other point that should have said, my responsibility to ensure the safety of my people and to warn them when I can't take away the risk. That didn't happen on this record. So what was the purpose? And I would say this as we're going through this. It was clear that the affidavits submitted with the response to the motion for summary disposition were considered. Therefore, it's no longer a C8 motion, it's a C10 motion. And you have, as this body, reversed a similar action in the case of Ousley, O-U-S-L-E-Y, versus Phelps Towing, Inc., under docket number 163602 on March 18th of 2022. And in that instance, you reversed the Jackson County Circuit Court, and you reversed the Court of Appeals, and you sent the case back because the tow truck operator hadn't been deposed. There was other discovery, but the critical person who was driving the tow truck had not been deposed. And you sent it back. You said there was a fair likelihood that additional facts would be discovered in support of the non-moving party's position.
Without human error here occurring, and that is the storage blocks placed in the press, I don't see the danger or the injury to the plaintiff. And so I'm trying to understand how discovery would help you when it's a matter of undisputed fact that some employee would have had to put these into the press in the first place before there's any danger. And so under the standards of the case law, where it has to be a known danger or imminent harm substantially likely to occur, how is discovery going to help you here?
Well, it's going to help me because we alleged in the complaints, as well as in the affidavits, that there were 5 to 10 instances that we were aware of where there was an ejection. And they say probability, statistics, they don't help you. But if every single time there was a compressing of the block and an ejection, that's 100% probability. So when the plant manager was told, you've got to stop using the metal storage blocks, and he says, my plant, my dies, my call, what does that tell you if every single time? That's how discovery is going to help me, because I know that there were other instances of ejections that we don't even know about, that I didn't have at the time I filed the complaint. So what you have, and the only person, because at this point, your question, Justice Zara, actually highlights my problem. Why do you use them? It's not like you're using them as some part of the compressing or the stamping process. It's called a metal storage block. And that, to me, infers that it's used when the dies are in storage. So if they're in storage, they're not being used. And if they're then being used, why are the blocks left in? Obviously, they were human nature. You know, they failed to take them out. But the point of the matter is, if you have an option to use wood or foam to protect the dies, why wouldn't you do that when you're told every single time that there's going to be an ejection when there's a metal block that's compressed? That's the reason discovery is going to help me. I need to find, and there are records, there's safety committee meetings where these storage blocks were discussed. Plant manager was there, head of the UAW safety committee was there. They exist, and I'd like to see them. And then I'd like to take Mr. Scrimmager's deposition. He's the only one who can tell us definitively why those blocks were still being used. I've heard anecdotally why they were used initially, but that was back when they used big air compressors to bring the top shoe down to the bottom shoe, and they are no longer being used. So why the continuation of using the metal storage blocks as opposed to something else? Because today, they use electronics and servos and computers and all those kinds of things. They don't use the big compressors. So it's supposed to stop the downward movement or upward movement when there's contact. Clearly that doesn't happen. So why use something that you know is going to eject and cause harm if it hits someone? I mean, here you have I think the most devastating injury you could possibly have, traumatic castration. There's no question that this could have been avoided. I mean, even if they had a sign that says, hey, watch your back, which is part of the notion that if you know something's going to happen, you have a duty to warn.
Counsel, one of the things defendant has asserted here is that the trial court assumed your allegations were true when it made its decision. How do you address that?
They assumed they were true, and they said there was nothing in the affidavits that alleged that injury was likely to occur. And so it goes back to the original question, how do you plead and ultimately prove that injury was certain to occur with no discovery? You're being asked to speculate, you're being asked to conject, if you will, about information and facts that are solely within the control of the defendant. How am I supposed to do that? I don't have a good answer to that question, other than the rules, which say you should have discovery and that it's premature to grant a summary disposition motion under C-10 when you go outside of the pleadings. And that's what's happened here. We were swept out with nothing. And we tried to get what we could get with the complaint, and it was not answered. They were not answered.
Counsel, I know there was a terrible injury in this case, but were there any injuries on the prior incidents that you were aware of where the blocks were left in the press?
Not that I was aware of, no.
So if there's, over the course of I guess you can correct me if I'm wrong, but over the course of many years, there are these incidents that happen maybe once a year or so, and there are never any prior injuries. How is it that you're going to show that an injury was certain to occur?
You're asking me to answer that question without.
Well, you're asking us to say that the minute you file a workers' comp intentional tort claim, you're automatically entitled to discovery. So
No,
that's
not.
that's not the law. The law is you have to have be able to make some factual allegations and then explain to us why you think further discovery will help you sustain or prove those allegations.
Well, if I may refer to the dissenting opinion, it said that the evidence provided by plaintiffs established that such storage blocks were ejected in a similar manner 5 to 10 times, which we've talked about over a period of years. Without discovery, the frequency with which the blocks were ejected is unclear. It's incredibly fortunate that no one else was seriously injured by the ejected storage blocks. However, that just because there were no other employees who were injured does not mean that the defendant lacked actual knowledge that an injury was certain to occur, given the dangerous nature of an ejection. In fact, we talked about what the plant manager said in response to the UAW asking him to stop using them. Thus, genuine issues of material fact exist regarding whether the defendant had actual knowledge that an injury was certain to occur and willfully disregarded that knowledge. And further discovery presents a fair likelihood of uncovering factual support for plaintiff's claim. I'm not asking for every single case that's filed claiming an intentional act exception. I'm saying in this case I had personal communication with the plant manager. He's the person who could have stopped this if he wanted to. He didn't. I have a person who was almost killed. I don't know if that counts. And his affidavit was in the file. And the point I'm making is I pled what.
I mean, the point is, before the injury, you have to prove that the company's representatives knew that an injury was certain to occur.
Right.
And here we have a situation where there's no evidence that an injury, that this condition occurred before, but there's no evidence that an injury, even one injury, major, minor at all, had ever previously occurred. So you could make an argument, I think, that it was likely that someone would again forget to take these metal blocks out of the press, and for which they apparently would be disciplined by the company. But since there weren't prior injuries, I have due regard for Judge Jansen, I have respect for her, but I don't, your reading her opinion didn't make it any more persuasive.
Do we know that there weren't any other injuries, or do we know that all you had at the complaint stage was that, to your knowledge, there wasn't, of those that you did know about, which arguably, I mean, you might be better situated than any other, like a number of other plaintiffs who don't have access to that sort of information to even put it in the complaint. But I guess that's the point, is like, we don't know the answer to that question. And you might not ultimately be able to succeed
Right.
if you can't establish some of these things. I think your point is where do we draw that line between, you're just saying magic words, here's an intentional injury was certain to occur, they knew about it, they didn't do anything. If you plead just that in a complaint, I don't think anybody would disagree that that's not sufficient. Where do you cross that line into at least sufficient to get to discovery?
Well, as I understand the law, as it relates to the injury certain to occur, it's inferred if there's a continuously operative dangerous condition that the plant has knowledge of and they ignore and fail to warn the employees. It doesn't require that you know that it's going to happen every single time, but it says if it's continuous and it's dangerous, as clearly the ejection of these blocks is, then you have a duty to warn at a minimum to avoid the intentional act exclusion to workman's comp and the inference that you knew it was going to happen and you allowed it to happen anyway.
A duty to warn is not a defense to an intentional tort.
I'm not saying I'm saying that one of the things that they have to show, I have to show, is that there was a continuously operative dangerous condition that was known to the plant representatives that they ignored and failed to warn the employees about. That's what I'm saying. That's, as I understand the law, I have to prove as it relates to injury certain to occur. That's the inference that's drawn. I'm down to about 2 minutes and 28 seconds, so I don't want to go over like the other gentleman did, so I'm going to conclude with what do I want? I'm not asking for a complete, full-blown briefing and all that stuff, because at this point on this record, it would not be helpful. What I'm asking for specifically is send this case back, let me conduct my discovery, and as Justice Kavanaugh said, and as Judge Jansen said, I may not be able to prove that there was injury certain to occur and that knowledge was known, but at least give me the opportunity. Any other
Thank you.
questions? Thank you.
May it please the court, Robert Ellis on behalf of General Motors, and with me at council table is my colleague Jill Wheaton. I will start out and just take a couple of minutes. There's nothing unique about this case that requires the court's attention. The contours of the intentional tort exception are well defined by both statutes and the prior decisions of this court. And as the court is well aware, and as was alluded to, the Workers' Compensation Act, in most cases, provides the exclusive remedy for workplace injuries. Now, in 1986, in the Beauchamp decision, this court concluded that the prior iteration of that act did not discuss what happens if you have an intentional tort type of situation, and the court created a test to allow intentional torts to proceed outside of the act. In response to that, the legislature amended the statute and created the intentional tort exception that we are here about today. In 1996, 20 some odd years ago, this court in Travis issued a very detailed opinion that went through the elements of the intentional tort exception and very clearly called out what needs to be shown and when. Nothing needs to be revisited at this point. We don't need to reopen Travis. And as set forth in Travis, a plaintiff needs to allege that an employer willfully disregarded actual knowledge of an injury that was 100% certain to occur. Not failure to warn, not likely, 100% certain to occur. In order for it to be certain to occur, it has to be a continuously operative, dangerous condition. What we have here, in this case, is in some ways similar to what we had in Travis, but this one is actually even less.
Counsel, wasn't Travis decided under C-10?
It was, but it doesn't make a difference here because it is, our motion, first of all, was not a C-10. It was an 8, a 4, and a 7. And dismissing these on C-8 is pretty common, especially after Travis, since this court set out what the elements were. But what you had in Travis were allegations of a press that every once in a while would double cycle. And that particular plaintiff in that instance happened to be using the press when it double cycled and was injured.
But didn't you also have in Travis, in the facts, that the manager or plant manager, I'm not sure exactly who it was, they knew that there was this thing they could do to the press, and I couldn't describe it correctly. They could do this thing to fix it and prevent the double cycling that was proposed, that was, prompting the potential for injury. And in fact, before the plaintiff used it, they had done this thing that every time they'd done it before, it prevented this double cycling, it prevented the problem. So, yeah, like maybe in that case, like you can't say that they had knowledge of this thing that was certain to occur because they did this thing that was supposed to make it certain that it wouldn't occur, right? And again, we're at C-10 after we've had all of these things sort of fleshed out. Why if you can plead, that, and it's not just saying the magic words, right? You've got something that says, I should be able to get to discovery. Like, I think I get that Travis set the standard in C-10, but tell us why this can't be C-4.
Sure.
Or C-8 or what have you.
Sure. The reason we can get rid of this one on the pleadings is the court appropriately considered that everything they alleged was true and everything they indicated they were expecting to establish on discovery was true. So again, if we think about the continuously operative condition idea, in Travis it wasn't there because it only cycled every once in a while and they took some steps to try to stop it. Here, this occurred even less often. According to the allegations, 5-10 times over the course of a long number of years, GM took steps to prevent it from happening. Employees were disciplined, and I believe walked out the door was the language in the declaration. So similar situation. It's something that happens only every once in a while. A continuously operative dangerous condition is like the companion case to Travis, the Golek case, where you have a room in which there is molten aluminum. And I believe the plaintiff was asked to go in and spray water on it, and if you spray water on molten aluminum, everyone knows it's going to explode at you. And that is the moment you're in there, you are in a situation that there is no chance that anything could happen to you other than getting hurt. Here we have a plaintiff who wasn't actually even working on the press, happened to be walking by the press while other employees were there. They failed to follow GM instructions and did not take out the storage blocks. They then turned it on, and for the 5th or 6th time in however many years, this thing happened to fly out and happened to hit this individual who just happened to be walking by. This is so attenuated that it's not the type of thing that you could call a continuously operative dangerous condition.
So we know plaintiff alleged 5 or 10 malfunctions over many years, but what if there were more? Isn't he entitled to at least find that out before having to defend against the motion?
No, and again, this is in Travis. So Travis actually said the fact that something happened before doesn't mean it's going to happen again.
It also said that maybe something's never happened, and Travis set out this, I'm glad you brought that up, that the laws of probability, which sets forth the odds that something will occur, play no part in determining certainty of injury. Consequently, scientific proof that 1 in 10 people will be injured is insufficient to prove certainty. Similarly, just because something has happened before on occasion doesn't mean it's certain to happen. Likewise, just because something has never happened doesn't mean it's not certain. So I don't find that super helpful, and it seems like that gives some leeway for the plaintiff to try to show they could fit under one of those things.
And I think the response to that is, again, and I'll agree it's a little fuzzy, but I think the point that they're trying to make is this has to be walking into a room with molten aluminum. It can't be walking past something that we know is potentially dangerous. It can't be going into an area where something might happen. It has to be as clear and as straightforward.
So I agree, to meet the standard, it's hard, it's a heavy lift, I agree. But to just get to discovery, why can't the plaintiff just get to discovery?
Because if we just get, well, first of all, even if we assume everything he says is right, that the facts as alleged or what he hopes to prove doesn't hit the standard. So one, why would we do discovery? But two, the whole point of the act and the exception is to keep these types of disputes out of the courts. We have a workers' compensation system. Plaintiff has a remedy. In fact, based on their briefing, they're pursuing their claims there right now. But what we don't want to do is open these claims up for, I'll call it a mini trial on this threshold issue, because it wouldn't really be a mini trial.
So in the cases you've cited, where it shows the very high standard, didn't discovery happen in those cases?
No, not in all of them. We have 5, I believe, that we've got in the briefing, and I can rattle them off if you'd like, but there's 5 in the briefing where they were dismissed on the pleadings or before the close of discovery. There were 2, actually, again, unpublished in Court of Appeals, so just providing it as information, but there were 2 since we filed our briefing where the Court of Appeals had affirmed dismissals based on C8 motions.
So your standard, it would be that the employer is ordering someone into a dangerous condition, the molten metal case, that would meet the standard. I mean, is that it? That's it? I mean, is there any other way somebody can get past that threshold?
It has to be 100% certain. It has to be, I am sending you in here, and I know in this situation you are going to get hurt. That is what the test is. And you happen to be cleaning the floors by a press that, if someone happens to disobey the rules, might shoot something out, and that might happen to be in your general direction, doesn't get us there. It has to be so egregious that it's only a degree or 2 away from punching someone in the face,
What-
because it is intent.
Well, but the
What
statute
if-
says,
oh,
okay,
go
sorry. I was just gonna say, the statute doesn't say that. It says it's still, we're in the realm of a tort, an intentional tort, a very high bar, but it didn't say it has to be criminal, it has to be like the most egregious thing ever, right? We're still in the realm of intentional tort. So this sort of, it's gotta be like, it's the rarest thing in the world. I don't know, I mean, I guess the legislature could have not made an exception. I mean, there might be some problems with that, of just saying, nope, you can never sue your employer because we have comp. But they made an exception that presumably has to be met in the realm of an intentional tort, still in the realm of negligence. We know there's negligence, there's gross negligence, there's, all sorts of varying degrees. We're still in that realm.
I would disagree with the reference to negligence, because again, it is the intentional tort exception. So it's not something that the employer was negligent about or grossly negligent about. It is something that has to be intended. So I'm not saying it has to be criminal, but it has to be either an obvious classic intentional tort, I'm going to punch you, or I am sending you in a situation intentionally where I know you are going to get hit or hurt. That
So
is,
if the employer knows that you're going to get hurt, but they send 100 people in on various days, and only 99 of them get hurt, and 1 person doesn't get hurt, how do you deal with that situation? Because you said 100% certainty that someone is going to get injured.
I think if you've sent 99 people in there and they've all gotten hurt, you probably are about as close to 100% certainty.
So it's not 100% certainty.
Right. It's just you have to be certain. So certain's
Is it
fuzzy.
98?
But it's certainly better, yeah, 98.
No, I mean, you make a good point. While merely showing something happened before is insufficient to invoke the intentional tort exception, how do we determine the point at which something happens often enough that the situation transitions from the occurrence of an injury being speculative to an injury being, I'll say, reasonably certain to occur?
I think like everything, it's a matter of degrees. And the easiest way to do it at this point is to look at prior decisions of the court. And when they've gotten there on the intentional tort exception, you don't even have to question it. It's, of course. Here's a person who's thrown into, again, the molten aluminum one is a good example. Another one.
Are you giving us we'll know it when we see it answer?
No, but it has to be, again, because there's a mental state aspect to it. So you have to allege allege facts showing that the employer, a supervisory person at the employer, put an employee in a situation where they knew the employee was going to get hurt. So are there some situations where that is more obvious than others? Yes. Is it a case-by-case decision? Potentially, but the statute and the legislature made that decision a question of law, which is what the statute says, and it's a question of law for the trial court. So
Am I fairly summarizing your argument or your answer to me to be, I can't really give you a clear definition of where that line is, to the extent you can make a bright line, but wherever it is, this is not even close.
I would say that's fair. I mean, I think where the line is depends on if you have allegations that show that a supervisory employee put someone in a situation where there was no doubt that that person would be hurt. That's how you get there, or at least get to discovery.
So
But
it's
here
the
we're not
next
close.
employee, after this employee that was injured, the next employee that gets injured by one of these, is there certainty there?
If the same situation? No. Because again, you're talking about it's not a continuously operative condition. It has to be something that exists all the time. So the other example, like the molten aluminum, would be there was one in which there was a spinning saw blade next to a garbage can that people had to continue to put things in. And that was another one where it's, okay, obviously they have their hands by it constantly.
For it to
Someone
be
is going
continuous, you'd have to have the blocks left in there all the time, right?
I'm sorry, I didn't hear the question.
For it to be continuous, the blocks would have to be left in there all the time, right?
Or it would have to be, if you wanted to take, and I'm conscious of the time, if you wanted to take this situation and make it fit, you would have to have a press that every time it dropped, something fired off it.
Well, in this particular case, these storage blocks somehow would have to be left
Right.
in there. And then it would be, I think if I understand your point, that would be the operator of the press, assuming they're in the line of fire, or some other employee that's consistently in the line of fire, there would be you get closer to this certainty to
Right.
occur.
And without the employer telling the employees not to do it? I mean, the
Right.
employer would have to say, this happens,
Yeah.
but we're not requesting or requiring that you take the blocks out. Is that-
Precisely. We don't care that these things fly off every time you use the press. Go in here, use the press, maybe duck. But that is
The
not.
plaintiff is alleging, I know of 5 to 10 times that's happened. Let me get discovery to show exactly that every time these blocks are in the press, they fire out.
But the point is that the blocks.
He's not saying, I have no idea if these things fire out, ever. I don't know if they've ever done it before, whatever. I'm just saying they could. It sounds like it. I'm going to put the magic words in the complaint. He has 5 to 10 times, and he's saying, if that's what I have to prove to meet that standard, let me have the process to be able to try and do that. He might not succeed, right? But he's like, let me get in the door.
And the difference there is the storage blocks were left in 5 to 10 times according to what he's alleged. Maybe it was more, but it's undisputed they aren't there all the time, and they don't fire out all the time. So that's where you draw the line here, is this is something that was left in, and every once in a while someone screws up and leaves it in, but it's not every time you turn on this machine, a piece of metal goes flying at people. And that's where the line is drawn in terms of the continuously operating issue. I see I'm out of time. So.
Thank you.
Thank you very much. I'll be very brief because I know you want to get going, but the reality is that he said it and said it well. It's the mental state, the intention that you need to show in order to have the intentional tort exception. It's a high standard, it's not an impossible standard. If it wasn't something that it was expected to be met, it wouldn't be in the statute. It's there. There's been no clarity as it relates to on an ongoing basis, but this is one case where, as Justice Kavanaugh is talking about, let me have my discovery to find out what's going on. When I asked about the mental state of Mr. Scrimger, I was told, you're asking about a non-party's mental state and it's objectionable. That's ridiculous. He's their
Do
employee.
you have a view on how many people out of 100 would have to be injured for us to conclude that an injury was certain to occur?
I don't. I can't guess on that, because here's
It'd
the
have to be
point.
somewhere close to 100, right?
Well, but here's the issue. We don't know why the blocks are used other than storage. That's the first point. If it was part of the normal operation, I would agree with you. I would agree with him probably, but it's not, as I understand it. But I'm not the person who can testify.
Doesn't that make the point that it wasn't continuous if it's not part of the normal operation?
But if it's continuously there, when someone screws up and leaves it in, and it happens every single time, I'd say that is continuous. That meets.
But just the words, when someone screws up.
Well,
I mean,
it's-
we have to take that into consideration when we're asking if this was intentional.
Well, but that's the whole point. If you know that people are going to leave things in and they are disciplined, walked out the door, so to speak, isn't that continuously happening? And I don't know the frequency. I don't know how often, I don't know when, 10, 9, 8, 7, I'm running out of time. But the point out is, send the case back, let me have discovery. Justice, go ahead.
If they're walking people out the door when this happens, then it's not, they don't have, it's not going to be an intentional tort. They're trying to stop it.
But it's after the fact. That's the problem. Unlike where they tried to correct the problem and they did something, it was proactive as opposed to waiting for it to fly out and then saying, oh, gee, well, we ought to punish the person who made the mistake.
But isn't the employer saying, do not leave these blocks in? Isn't that proactive? And then it's somebody
What's more-
independent of the employer not following that.
What's more corrective is using wood or foam to do the same thing that the metal ones did. You don't have ejections with wood and foam. That's the difference. That's what they could have done. And miraculously, the day after John Doe was injured, no more metal storage blocks. They had the capacity to do it all along and didn't do it. That's what needs to be discovered. Why?
Isn't the idea that nobody was injured, as far as we know, before this, and once there was an injury, then they took action? I know we're looking now at subsequent remedial measures, which,
Well, you're actually also looking at control and the opportunity to make you're not looking at it to prove the elements, but you're talking about something that they had the ability to do it. And this man wasn't
things
just
can
walking.
always be made safer. There's no question. We see this a lot in these kinds of cases, that things could always be safer than they are, but that's not enough to show an intentional tort that they didn't choose the absolute safest way to do everything, right?
This gentleman was a part of a skilled trades training team. He wasn't just walking by. This was his assignment to work on this press. He was where he was, and he chose to help other members of the team, and that's why he was positioned. So if there's if there are notes about the skilled trades training teams being exposed to these ejections, again, I'm speculating. We're all speculating. Give me my discovery, please.
Okay, thank you, counsel.
Thank you.
Thank
The
you.
case will be submitted and the court stands adjourned.
Thank you.